Okay, I think we're getting started. Thank you for your patience. We're going to start now.
All right, first it's a great pleasure to be here, and particularly to be introduced by John Marshall, who I've, as a fellow Virginian, we read cases like Marbury versus Madison and so forth. Now, we've agreed to talk about several issues: presidential signing statements, state secrets privilege, the indefinite detention at Guantanamo, and for those who are tried, the trial by military tribunals versus civilian federal district court, warrantless electronic surveillance, and finally the National Security Agency data mining program that accessed phone records trying to find out who was talking to terrorists. There's one issue that I think we've agreed is a non-issue because we both agree on it. In 2007, I co-authored a piece in the Washington Post with former Marine Corps Commandant P.X. Kelly called War Crimes in the White House that was very critical, as you might imagine from the title, of the abuse of detainees. There are some people who note, I think correctly, that waterboarding helped us get information that saved lives, but we have made a commitment under Common Article 3 of the Fourth Geneva Conventions of 1949 to treat all detainees in armed conflict humanely. And one can argue whether waterboarding is torture or not, but one cannot argue that it's humane treatment. Now let's start off with presidential signing statements. There's some people that see President Obama as just another George Bush, and they wonder if there's something in the White House water that makes people disrespect the Constitution as soon as they move in. Why else would a Democratic president claim to have a right to ignore the law when we all know that the president has a duty to see the laws faithfully executed? In 2006, the American Bar Association, in a meeting in Honolulu, unanimously approved a resolution declaring that signing statements were contrary to the rule of law and our Constitution's scheme of separation of powers. And as the candidate for office, now President Obama, was very critical of signing statements. And just to give you an idea of what they are, here's a typical Bush signing statement. Provisions of this bill would interfere with my constitutional authority to conduct foreign relations, and thus I'm not going to pay any attention to them. Oh, that was Obama's signing statement in 2009, but it's hard to tell them apart. Now, under the Constitution, Congress is empowered to enact laws, and the President is required to see them faithfully executed, which is a general principle, is not in dispute. But we have a hierarchy of laws in this country, and at the very top is the Constitution. And the President takes an oath of office. He's charged not only with seeing the laws faithfully executed, but also he swears that he will preserve, protect, and defend the Constitution. And what happens when a president thinks a statute is unconstitutional? Is he required to enforce it? If he does enforce it, is there any easy way to get a case of controversy before the Supreme Court? Because the court can't give advisory opinions. If you've got the branches truly at odds, they will find standing. They've rejected congressional standing time and again because only a small number of members of Congress have filed the suits. And basically the court has said, go back and get a majority, and we'll talk about this again. Now this was not a signing statement, but the first presidential expression of the principle that the president is not obligated to enforce unconstitutional laws came when Thomas Jefferson became our third president in March of 1801. And he announced that he was not going to enforce the Alien and Sedition laws because they violated the First Amendment. And he further pardoned all of the people who had been convicted and had their fines refunded. That upset John Adams greatly, in part because of one of the people he pardoned, but that's another story. But did that make Jefferson a lawbreaker? And remember, before you answer that, what John Marshall said in his earlier life, in that esoteric case that you've probably covered at Marbury versus Madison, when he said an act of the legislature repugnant to the Constitution is void. It is not law. If it is not law, it is not one of those entities that the president has a duty to see faithfully executed. And I would submit that when the president must choose between upholding the Constitution or enforcing a law that he is convinced is unconstitutional. And I would also argue, and we can take this up in Q&A, that in the overwhelming majority of cases, both Bush and Obama were exactly right when they refused to carry out these provisions. Now, the actual practice of using signing statements dates back to 1822 when James Monroe was president. Often, these signing statements are done to protect individual rights. If you haven't read the Lovett case, I commend it to you, United States versus Lovett. In 1942, the powerful chairman of the House Appropriations Committee on an urgent supplemental appropriation for the war, this is money we had to have or we might lose the war, stuck in a rider saying that no funds in this or any other act shall be used to pay the salaries of three named, quote, subversives. The House Committee on Un-American Activities had heard testimony that these guys may be commies, and so he decided he was going to just take care of that right away, and he put a rider in, and he refused to drop it. And time and again, both the House minority members and the Senate denounced this, and they said, you can't do this. This is a star chamber. It's a witch hunt. It's a legislative lynching. And the Senate turned down the conference report 4 times because of this clause. But we were about to lose the war. And so FDR went to the Senate and said, for God's sake, pass the bill, and I'll deal with this particular clause. And he issued a signing statement saying that Section 304 was unconstitutional and thus would not bind the executive or the judiciary. Now, should he instead have said, no, my job is to salute and carry out whatever Congress passes, or should he have considered his obligation to the Constitution and the principles of the Bill of Rights? Was he a lawbreaker? Well, I'll let you decide that. It took 4 years for the case to make its way to the Supreme Court, and finally, in 1946, the court rejected the argument of congressional counsel that this was just an appropriations measure and thus was a non-justiciable question. Congress has complete control of the purse, and they can put any rider on an appropriations bill they want to. The Constitution be damned. They also went on to say this was a bill of attainder, which happens to be prohibited by Article 1, Section 9 of the Constitution. Now, why do we have so many more signing statements today than we used to have 100 years ago? Well, we have a law-breaking Congress today. I hate to say that, but it's true. I worked in the Senate for 5 years in the mid-1970s, and in June of '76, I drafted a speech explaining why legislative vetoes were unconstitutional. A lot of people said, hey, that's well-reasoned, Bobby, you're wrong. 7 years later to the month, the Supreme Court in the Chatta case paraphrased basically all my arguments. I'm absolutely certain they hadn't seen it. It was just, we all looked at it. It was very clear that this was an unconstitutional usurpation of executive authority. Since 1983, when the court clearly said legislative vetoes are unconstitutional, Congress has enacted well more than 500 additional legislative vetoes. And the overwhelming majority of signing statements are saying Section 401 of this bill is a legislative veto and pursuant to Chatta has no effect and will be ignored. If presidents don't resist unconstitutional acts by Congress, we will quickly abandon the doctrine of separation of powers. Congress will seize all powers through conditional appropriations. I first used this next example back in 1981, but I've updated it by calling it the Supreme Court Neutralization Act of 2012. No funds shall be available, and you can fill in the blanks, unless the court overturns Roe v. Wade, if the court overturns Roe v. Wade, unless the justices appear before the Senate Judiciary Committee on every Monday they're in session to get instructions on how to decide ongoing cases. The fact is, without money, the court cannot function, and if we take away the separation of powers principles and pretend Congress by rider can do anything it wants, we lose separation of powers. Now let's briefly talk about state secrets privilege. There are two bases for it. One of them is an old common law rule we got from Great Britain. The other one is a constitutional commitment of power to the executive branch. Madison, during the famous debate in the Jay Treaty, acknowledged that the president had the right to deny information to Congress. Congress could not compel the president to give them information. In United States versus Reynolds, the Supreme Court said in 1953, even the most compelling necessity cannot overcome the claim of privilege if the court is ultimately satisfied that military secrets are at stake. This is clearly a statement of an absolute executive privilege. Professor Ed Cornwell of Princeton University said, so far as practice and weight of opinions to settle the matter is today established, the President is the final judge of what information he shall entrust to the Senate with regard to our foreign relations. The same logic applies to giving secrets to the judiciary, which the Supreme Court in the Nixon case noted. The court emphasized Nixon doesn't place his claim of privilege on the ground they're military or diplomatic secrets. As to these areas, the courts have always and traditionally shown the utmost deference to the President. And they went on to quote one of their earlier cases, it would be intolerable that courts, without the relevant information, should review and perhaps nullify actions of the executive taken on the information properly held secret. In 1875, the executor of an estate of a man who claimed that Lincoln had hired him to go behind Confederate lines and become a spy, his estate sued for money. Well, Lincoln was dead, he was dead, and the court said, as a matter of public policy, we will not allow suits in a court of justice, the trial of which would inevitably lead to the disclosure of matters which the law itself regards as confidential. They went on to say, to note there are other, we don't require husbands to testify against their wives and priests against their confessional privilege. Much greater reason exists for the application of the principle to a case involving contracts for secret services. That was a unanimous case. In 2005, the Supreme Court again unanimously upheld this principle, which they say we recognized in Reynolds the privilege against revealing military secrets, and they went on to say it is beyond judicial scrutiny due to national security reasons. Now, what about detention at Gitmo? There's nothing inherently wrong with Gitmo. Indeed, it is a model prison. It's very excellent facilities as far as prisons go. They get better medical care paid for by the American taxpayers than many Americans can afford. In one case, we paid hundreds of thousands of dollars to bring in a cardiologist because we believed that one of the detainees had a heart problem. It had nothing to do with us or the war, and we didn't want him to die in detention. So we paid a fortune to make sure he was taken care of. And we've also repaired all sorts of injuries that go back to when the Mujahideen were fighting the Soviets back in the early 80s. So the general treatment there has been quite good. More importantly, closing Guantanamo is not going to solve the problem. We've already solved the problem of detaining abusees. The problem now is largely one of ignorance of the law. The head of the ACLU National Security Program says closing Gitmo will be an empty gesture if we just reopen it on shore under a different name. If you close Gitmo but leave individuals detained without trial or without charge or trial, you're just making a cosmetic change. The fix here is to explain to people there are two paradigms at play. One of them is a criminal law paradigm that says if the government picks you up, they must charge you with a crime, take you before a magistrate, give you access to an attorney, and so forth. We're not in that particular paradigm. We are in the law of armed conflict paradigm. We are, in fact, at war. Some people don't like it, but everybody who has a voice in the matter has said we are at war. The AUMF passed right after the 9/11 attacks authorized the president to use military force under the War Powers Resolution. Both Presidents Bush and President Obama have said we are, quote, at war. The Supreme Court has repeatedly said the law of armed conflict applies to this conflict, and it is lawful to detain enemy combatants without trial for the duration of the conflict. This is not the war on poverty. Most critics don't understand that it's a long-standing principle under international law of armed conflict that during conflict, if you capture enemy soldiers, you hold them under humane conditions until the end of the conflict, at which time you exchange prisoners. There's no right to a lawyer, no right to a trial, just because you're a POW. Now, if you are charged with a crime, then you do get rights, and they're very important rights. During World War II, we had more than 400,000 German POWs at POW camps across more than 40 American states. They did not get to see judges, they did not get lawyers, they were held for the duration of the conflict. These are some of the books about these various camps. Moreover, transferring a POW, now remember these detainees are not POWs under the Third Geneva Convention, but transferring a POW to a civilian penitentiary is a violation of international law. The Third Geneva Convention on POWs requires that they shall be held in military prisons. What about military tribunals versus federal district court? Well, I'd have to rush real quickly because we don't have enough time. But basically, the Constitution empowers Congress to make rules for the regulation of the land and naval forces. Congress has done that in part through the Uniform Code of Military Justice, which specifically authorizes in Article 104 trying anyone involved in aiding the enemy during armed conflict, harbors, protects, gives intelligence to, holds any intercourse with the enemy can be tried before a military tribunal. Congress has expressly endorsed by law trying detainees in the current war by military commissions. And very importantly, again, Article 84 of the Third Geneva Convention says a POW shall be tried only by a military court. So if we decide to move them to American prisons and try them by civilian courts, we will be violating the principles of the Geneva Conventions. Now, we're not violating the conventions because these people don't qualify for the full protection. But I will tell you one anecdote. I was in Michigan last week giving a talk, and the chief federalistic judge, who I worked with on the Hill back in the 70s, told me that one of his friends was an attorney for one of the Gitmo prisoners who is now in a supermax prison in America, and he told his lawyer he hoped he could go back to Gitmo. Why? Because they have access to soccer fields and a lot more freedom of movement on Gitmo than they could have at a supermax prison. The argument that military tribunals are unfair is an outrage to anyone who's ever served in the military. We try American soldiers every day in military courts, and it is a fair system. The rights of the enemy are determined by international, the rights of the defendant are determined by international law, not by U.S. law, and that's the way it ought to be. We really want to give foreign terrorists more rights than we give to our own troops. They're not covered by the entire Fifth Amendment. Now again, international law is the key. Protocol 1, for example, says they should be prosecuted in accordance with the rules of international law. Now, we want to change it and say, hey, now the new rule of international law, we're modifying customary law here, and you will be tried by the internal law of the country that holds you. After World War II, Korean War, North Vietnam, Saddam's Iraq, we don't want to change the rule that says international legal standards prevail in these cases. And setting a precedent to the contrary might be a real bad idea. Warrantless electronic surveillance, just a few things. One, John Jay noted, and it was the historic practice until the 1970s, that Congress had nothing to do with intelligence. The Founding Fathers, the first Congress in appropriating money for foreign affairs, told the President to account specifically for the expenditures he thought could be made public and for the amount of other expenditures. Why? Because this was viewed as presidential material. Henry Clay, the great House leader in 1818, said it would be improper for Congress to inquire into how the President spent money from the Secret Service account. And I would submit Congress cannot take away the President's power by a mere statute. Article 5 tells us how we amend the Constitution. John Marshall reminds us again that an act of the legislature repugnant to the Constitution is void. 1968, when Congress enacted the first wiretap statute, it expressly noted this statute doesn't limit, quote, the constitutional power of the President to obtain foreign intelligence information. Congress understood this was the President's bailiwick as part of the executive power. The Fourth Amendment prohibits unreasonable searches and seizures. And it applies every bit as much in war as in peace, but what is reasonable in war may well come to a different balance, because if you're trying to save large numbers of lives, that's not the same thing as trying to catch someone on tax evasion. Since '67, the Supreme Court has had an opportunity in 2 cases to hold that foreign intelligence surveillance requires a warrant. Both times they have expressly excluded that option by footnotes. United States versus Cass and United States versus Keith. The 3rd, 4th, 5th, and 9th Circuits Court of Appeals have each recognized a foreign intelligence exception to the 4th Amendment. No court of appeals has ever held to the contrary. The 6 times since 1967, the Supreme Court has had an opportunity to require a warrant for these types of cases. It has refused to do so, and in the Trung case, which I'll talk about in a moment, not a single justice voted to grant cert. Now, we are not supposed to draw conclusions when they don't grant cert, but surely, if the justices had thought that the Bill of Rights was being violated by this practice, somebody would have said, let's hear the case. The Trung case is an interesting one. It's Jimmy Carter, and Carter says, or the Carter Justice Department authorized breaking into a man's home, bugging his phone, planting microphones, putting a video camera in his office. He was convicted of espionage. When his lawyer tried to throw out the case, the D.C. Circuit Court of Appeals noted that the district court found a foreign intelligence exception to the warrant requirement, and we agree with that position. I'm going to skip these cases. Let's see. When FISA, I worked on FISA when it was before the Senate in 1978. Attorney General Griffin Bell said, hey, this can't take away the president's power in this area. It created a court of review, the FISA Court of Review. And in 2002, the FISA Court of Review, made up of U.S. Court of Appeals justices appointed by the Chief Justice, noted all the courts to decide the issue have held the president has an inherent authority to conduct warrantless searches to obtain foreign intelligence. We take it for granted the president does have that authority, and assuming that is so, FISA could not encroach upon the president's power. It was a unanimous opinion. Now, warrants are not required. I'm going to skip this. It's fairly common stuff, but there are a lot of exceptions. Every time I go into an airport, I get searched. That's a Fourth Amendment search, and the court has said because of the risk of a plane being blown up or hijacked, that outweighs the individual rights of passengers. And obviously, when you're talking about terrorist attacks, it's a much greater balance. It is absolutely absurd to suggest that it's unreasonable for the government to listen in when a known or suspected terrorist in a foreign country is talking to someone in this country we know nothing about. They might be planning the next attack. They also might be learning about how to deliver the lamp the guy sold on eBay. If that happens, there are minimization procedures that require them to destroy the tape and so forth. Let's see, data mining just real quickly. What we're talking about here is phone companies voluntarily making available electronic data that includes no names, no content, just what phone number talk to what phone number. And the purpose is to run known phone numbers used by terrorists or believed to be used by terrorists and see who's talking to them. And if they come back and says, hey, this particular guy's talked to 6 different terrorists, then we want to know more about him, and we start inquiring more. So, this is the Supreme Court in Smith versus Maryland in 1979 upheld the use of a PIN register, which is a device the phone company uses to capture the phone numbers being dialed by someone. And so this is not a new issue. It has been resolved. It's very much like when the cops come to the scene of a crime and they find a handgun and no suspect. They find fingerprints, they send them to the FBI. They have 1 billion fingerprints roughly at the FBI. They search it, and as they go through it, they hit my file for a micro nanosecond, said, nope, not Turner, and they go on. Another example, little girl, 12-year-old girl standing by her bus stop waiting to go to school. Some pervert swings over in his pickup truck, grabs her, yanks her in the truck, and speeds off. What do the police do? Well, they interview the other kids, and they say, well, the last digits were 028, and it was a dark, new, or old, like Ford pickup truck. They go to DMV, and they run the DMV records to find owners of trucks that match that description with those last 3 digits. And then they take those names over to the police department, and they run the database on convicted sex offenders, and maybe, just maybe, the little girl is saved before she's butchered. The fact that a government computer pauses briefly for a micro nanosecond on your or my license plates is not a serious violation of our civil liberties. I look forward to taking questions at the end of the program. Thank you.
Now, Professor Culbertson will offer a response.
First, thanks to you all for coming and thinking about these things with us, and especially to Professor Turner for coming to work that he has done for a good minute at UVA and elsewhere, especially with the programs on national security there, are something for which I'm particularly, and I think all should be grateful. In the interest of time, I'll limit my response to a few points which I think actually come together in some ways. Earlier, Professor Turner understandably mentioned the interpretation that, right, the United States in time of armed conflict is subject to Common Article 3 of the Geneva Convention. It's called common because it's in all of the 49 conventions. He also recognized that the present interpretation by many is that persons detained who are associated with or in fact operatives of Al-Qaeda, Taliban, or similar non-state groups affiliated with or targetable under the authorization for the use of military force are not prisoners of war. Right? They're not prisoners of war under the conventions because the Article 3 sets a bare minimum of standards that non-state actors must meet in order to receive that status. Now, it's an incentive, right, for non-state actors, specifically thinking about, liberation, revolutionary forces. It's an incentive for them to comply with the laws of war. And so there is the interpretation that because groups and operatives affiliated with Al-Qaeda, for example, do not carry arms openly, for example, target civilians, do not
Uniforms.
have recognizable insignia, right, that they do not meet the minimum standards, and so they don't receive the incentive benefits. Then, though, and I certainly understand why Professor Turner mentioned it, he made reference to the provision from the Geneva Conventions that no prisoner of war may be transferred to a civilian prison, a civilian trial, that a prisoner of war has to be tried by a military court. Now, of course, as Professor Turner noted, that doesn't technically apply if we're saying that these individuals are not, in fact, POWs. But there's the sense that the spirit's the same, right? That the spirit of it should be the same. Because these are enemy combatants, right? Persons with whom we acknowledge we are in armed conflict or authorized force or war or a fight, call it what you like. There's the sense is that the spirit of the Geneva Convention and of international humanitarian law generally should suggest that that kind of transfer into a sort of criminal domestic process rather than a military process based on international law would still not be really what we want to do, because even though they're not technically POWs, they're POWs. Well, I think that argument goes in the other direction as well, right? I think accepting that means also recognizing that under the spirit of the conventions, and recognizing the increasing prevalence of asymmetrical conflicts, right, between non-state political communities who, for all kinds of reasons, including disparate resources, right, find it attractive and effective to violate the laws of war, right, to not carry arms openly, to, in fact, make use of either civilian targets or civilian infrastructure as either a place from which to launch attacks or a place to attack, right? Recognizing that reality, I guess I want to support the spirit of carrying the spirit from the international humanitarian law on prisoners of war into the context of discussing these persons who we nonetheless want to maintain are not properly prisoners of war. Now, the way that I'm interested in doing that is not actually through sort of the direct authoritative application of the Geneva Convention in the U.S. court, so much as understanding and incorporating the customary principles of international humanitarian law as the very meaning of due process in the context of armed conflict, detentions, trials, and punishments. That is to say, what is the due process clause? Right? Okay, so the due process clause of the Fifth Amendment says, it says, no person shall be deprived of life, liberty, or property without due process of law. It's not real fancy. What is due process? Well, that just means they can take your life, they can't take your liberty, they can't take your property, as long as they do it the way they're supposed to. Right? Okay, so it's a very capacious term, due process. Right? Procedures that you are due, the right way to go about things. I mean, it's a very capacious, open term. And this is how we've seen, for example, that ultimately federal criminal due process, in many respects, constitutionally required federal criminal due process, has been incorporated through the Due Process Clause of the 14th Amendment to apply to state criminal proceedings. It wasn't total, wasn't absolute, wasn't immediate, and as many others have argued, the similar form of incorporation could easily be done in the context of international humanitarian law defining the process that is due any detained person in military custody. And this is where I would urge those like myself who are concerned about and frequently discuss either the processes by which persons are identified as terrorists or detained as combatants or tried as war criminals. Also pay great attention to the system of military justice in place for service members. And if we want to ask serious questions about whether a deviating process in terms of protections, in terms of constitutional procedures for criminal prosecution, if we're serious about that for enemy detainees, we have to also simultaneously ask serious questions about the standards of process for our own service members. Because one of the traditions, in some ways, in international humanitarian law has been there should be, as close as possible, parity between the processes afforded one's own service members and those of one's captured enemies. Now, I say all of that just to make the point that concerns we might have about detentions, concerns we might have about procedures by which detainees are then identified as subject to criminal prosecution, and concerns we might have about military commissions necessarily do rely on international law. The Uniform Code of Military Justice itself makes reference to the laws of war, right? But also, I'm suggesting that the Due Process Clause of the Constitution should, as it does, change across contexts. And in this context, the context of detentions and trials in armed conflict, incorporate and thus be authoritative over the methods that we use. Now, what does that mean? Does that mean that I think that all these trials should be federal criminal trials? No, I don't. I had the privilege of working with the Office of Defense Counsel in the Department of Defense's Military Commissions Office, and I will just say from my experience, I've never seen, not just from the defenders, but from the judges, a more rigorous, serious, and humble sort of approach to the process with the concern over and fairness towards persons charged. That being said, all right, do I think we should do I think they have to leave military process? No. The question is, what does that process look like exactly? We have traditions that suggest that military commission trials should deviate from courts-martial only when it's impracticable not to, and then courts-martial should deviate from federal criminal trials only to the degree that it's impracticable not to. So it's a narrow standard. And in all of these conversations, right, I guess I'm very interested in, again, what I suggested about this. There are these ways in which many of us want to bring certain elements from the law of armed conflict or from international humanitarian law over into and apply to the context of these kinds of counter-terrorist situations. But then we don't want to bring everything over. And we sort of are having it both ways a lot of the time. For example, again, how is it that we can try individuals under international law regarding armed conflict for violations of that law and not take an expansive reading of that law's protections at the same time? That's a concern to me. Another fundamental concern to me that plays out in the context of the detentions and of the commissions, which fails to be addressed by the courts or by the political branches is the consistent discrimination on the basis of citizenship that has taken place since the first executive order. Right? That non-citizens are subject to these procedures and provisions. Right? Well, it seems to me that if we're arguing that this is a novel war, that we're arguing that this is a novel situation, if we're arguing that, as Attorney General Holder's comments yesterday about targeted killings of citizens abroad made very clear, we are in a conflict where frequently citizens, either here or elsewhere, are part of the forces against us. Recognizing that fact, the continued subjection of non-citizens to differential treatment, even under the most recent Defense Authorization Act, to me is a fundamentally irrational distinction to draw. Paperwork and birthright, to me, don't make any meaningful difference in the kinds of process a person should enjoy and whether they should be before a military court or a civilian court. And nonetheless, this distinction between citizens and non-citizens continues. I do think it's an equal protection problem, but I think it also manifests and speaks to a more general cultural problem. Because even yesterday, as Attorney General Holder was speaking, he said, and I quote, the Supreme Court has made clear that the Due Process Clause doesn't impose one-size-fits-all requirements, but instead mandates procedural safeguards depending on specific circumstances. No doubt. No doubt. We can have different, well, we do have different types of due process, for example, in deportation hearings than in traffic court, in criminal trials than in divorce court, right? There are different sorts of process. However, there are fundamental minimums, and we may want to consider that. But Justice Holder went on to explain the Due Process Clause a bit more, and stressing that the Fifth Amendment's Due Process Clause says that the government may not deprive a citizen of his or her life without due process of law. That is not what it says. It says that no person may be deprived. It certainly does not mention citizens. The Constitution mentions citizens in other places. And explicitly in the Due Process Clause and the Equal Protection Clause mentions person. I don't think Attorney General Holder has forgotten the Fifth Amendment. I think that is a falsehood. And I think that deep consideration about what the rights of the person are in the context of investigation, detention, etc., is warranted. I agree in some ways with Professor Turner regarding data mining insofar as our constitutional text regarding the Fourth Amendment is, I think, actually quite porous and protects the people, not persons, in a very limited way. And I suppose the final comment that I would make in regard to signing statements, not signing, excuse me, in regard to state secrets is this. And much of my sort of most recent thinking on these matters have been shaped very much by a remarkable paper that one of your colleagues, Sean Kelly, is writing on the ways in which the state secrets privilege is being interpreted by the court. So we have these two lead cases, Totten and Reynolds. Right? There is an increasing absolute character to the privilege. Right? Privilege asks, on one hand, right, is it possible to undertake this civil hearing without, for example, disclosing the classified military information? Well, that's clearly privileged. We understand that. But how do we even find out to what degree it may be dangerous, problematic, troubling, etc., to disclose the information that might come out in a trial? Well, presumably you find out by having the judge look at the information that might come out in discovery to see whether or not it may in fact be dangerous to disclose. It's more and more popular among judges, though, to have adapted Reynolds to a two-part test that, in the second part, asks, would even considering viewing in camera, right, the information alleged to be so dangerous, would even isolated viewing by the judge, right, be improper given how, again, dangerous this information might be if revealed. That worries me. The declaration that the subject of a suit in and of itself prevents and should not allow for even private scrutiny by a federal judge concerns me. And it concerns me especially because it's coming up primarily in tort suits being brought by former detainees, later cleared and released, who have brought suit either against individual government officials or subcontracting corporations that facilitated their abduction, detention, abuse, and release. And as such, these cases are coming out right at the pleadings. So, before discovery, etc. And this, as a larger cultural matter, prevents us from even having a record, an archive of the claims of what it was the last 10 years have included. That, for me, as well as the concern about due process and developing an actual standard based on international law, but defined by our own U.S. law for detentions and procedures involving enemy combatants. Those are the things about which I'm most concerned. And those are the questions of freedom that I suppose I would like to hear more about.
We got just another minute or so. I know some of you probably have to dismiss and head to your next class, but I would invite Professor Turner to come up and respond one more time if he has any comments to follow Professor Culbertson.
Yeah, just real quickly here. He referred to international humanitarian law. I think the better view is that the law of armed conflict is lex specialis, which means that it overrules basically inconsistent provisions of the more general international humanitarian law. And that certainly is the view of the top experts in the U.S. military. Mark Martin is his brigadier general, who was #1 in his class at West Point, the only one to be #1 at West Point and commanding General Staff School. He is now in charge of military commissions. He's an old friend. I could not think of a more honorable person to make sure that the defendants are going to get fair treatment. So there were some problems in Bush's first commission efforts, in part because the judge advocate generals were excluded from the process. The important thing, he said, it's irrational to treat citizens differently from foreigners. And I'm not sure I disagree with that. There is precedent in the Quarren case in 1942. Some German saboteurs landed in civilian clothes in the United States with explosives in the purpose to blow up bridges and factories and things like that. And they got compromised early and they were arrested, and the Supreme Court upheld trying two of them. One of them was clearly an American citizen, and at least one of them was, and there was at least one, they had all lived in America before. And so others had claims to being an American citizen. The Supreme Court said it doesn't matter. And they tried them by military commission, and all but one were executed as a result. Let's see. Just the last point he made, or one of his last points. He thinks judges ought to see the material to decide whether it's classified or not. The problem is judges aren't trained to know all of the various factors involved in this. Just for example, what if the judge saw the government wanted to keep out the fact that we were conducting operations in country X, Pakistan, whatever, with the consent of that government, but it was a very secret private consent. And the judge said, oh, that doesn't really matter, I'm going to make that public. And the next thing that happens is that government is overthrown, or if it's a democratic government. I worked in the White House in the 80s and also in the State Department. And I know of cases where European countries told us, hey, Carlos is in room 401 of the Intercontinental Hotel in Paris. If you can get him out of there, please take him. But if it becomes discovered, we are going to denounce you for interfering on our internal affairs because we don't want his friends, kidnapping our citizens around the world and killing them and so forth. In that setting, you have consent to do the operation. If that operation becomes public, it could, tremendously destroy your relations with that government, lose you the right to operate in the government and so forth. And so the Supreme Court has traditionally taken the view, if it's a military secret, the judge should not even see it in camera. Anyway, I'm going to stop there. If there are any questions, I'll stay as long as you want, but I know some people have classes, and this was a great pleasure, by the way. Great presentation. It's an honor to do about the debate.
I'd like to thank everybody for coming. If you have any questions, I would encourage you to stay a couple minutes afterwards. We have to yield to the incoming class. We are out of time, but I understand there are some people who have class, some who don't, but the professor will be here for a few more minutes following. Thank you, Professor Banks, for joining us today and coming off your leave.
Professor Culbertson.
And Professor Culbertson.
Oh, is Professor Banks here?
Professor Banks.
Oh,
is
hey,
the
I
guy
didn't
the
see you in
room.
the back. Sorry, great to see you.
Kelly Perrin, I advised her in the in-skit office of your visit, and she, I think, let Professor Banks know, so we're
Well, thank you.
glad that you joined
Bill.
us. Thank you, everyone, for coming. Please help me show appreciation for our Well, I knew you were off, and the interesting thing, I got another captain coach, Kelly. Yes, sir, he's coming in 20th. And we would love to have you involved on the really awesome.
I'm honored to have you here. I was told you were off this semester. Yeah, well, that's great. I think you're doing a great job with the National Security Law. And I tried to get the committee to provide some funding and what way to do it. And then when I was teaching that one of the participants on some research decided he wanted to do it in Australia and